we're glad you tuned to Law Matters, a show that is educative, informative, and offers a legal aid solution to what we face on our day-to-day lives. Tonight, we're talking about the issue of civilians being tried in military courts. This comes days after we saw the opposition leader in Uganda, Kizza Besigye, go on a hunger strike to impede him being tried on a military court. Can that happen in Kenya? And what laws are there to find out whether that can happen in the country? My name is Irene Mwangi, but before we debunk this particular discussion, let me allow my guest to introduce herself kindly.
Thank you so much, dear viewer. My name is Osiemo Emily. I'm an advocate of the High Court of Kenya. I'm a former lecturer at Kenyatta University School of Law, and I have been involved in a number of matters. I'm a member of the Pan-Africa Lawyers Union, and I was part of the observation mission that went to Uganda to observe the trials of Kizza Besigye and all the political detainees. Thank you.
All right. Thank you so much, Advocate Emily. Perhaps looking into what happened in Uganda, questions have been raised whether that can happen, in the country. Can civilians in the country be tried in a military court, and what are the legal parameters surrounding that?
Thank you so much. Kenyans pride themselves of the current constitution, the Constitution of Kenya 2010. Perhaps if it wasn't for that, we would be facing dictatorial regime. We are very lucky that after the 2010 Constitution, we enjoy so many rights as a country that we take for granted. And once the Constitution was enacted, all the acts had to be aligned with the Constitution. One of the acts is the Kenya Defense Forces Act, KDF Act.
Okay.
So that act allows a civilian only to be tried in a court-martial if they are only related to or they are linked to a unit of KDF, and they must give a consent in writing that they shall be subjected to the KDF Act and subjected to the court-martial.
Okay.
Otherwise, civilians are not subjected to court-martial. There are so many offenses, if you look at that act, that even if a civilian is linked to a unit of KDF, they will be tried in a civil court.
Right.
For instance, aiding desertion, abetting some offenses, they will be tried in a civil court. That's what that act provides.
So is that to say that a civilian cannot be either a party to a case or an interested party in a case, given that the act expressly says that a civilian can only be tried in a civilian court, even though there's some sort of link with the KDF forces or any arm within the army?
Thank you so much for that question. They can be tried if they have given a consent in writing.
Okay.
Because that act not only just requires them to be linked, they must give a consent in writing. So if there is no consent in writing, they can't be tried. And it's only for such serious offenses. For instance, minor offenses like aiding, abetting, even if they have that consent in writing, they can't be tried because the act says that those civilians be tried in a civil court. And that is important because our constitution has put an architecture of courts. We have a judiciary. That judiciary has a series of courts. Court-martial is just a subordinate court. We have other competent civil courts that can hear and try matters or offenses that are under penal court. Yeah.
All right. Now, when it comes to the laws and the offenses, as well as the punishment that comes with either court, that is a civilian court and a military court, are there different sort of framework that guide how a judge can rule in a military court vis-a-vis a civilian court? Is there really some sort of departure when it comes to those two courts?
Thank you so much. Let me start with a court-martial. A court-martial is just there for purposes of hearing disciplinary matters involving the defense forces. That's basically what it's supposed to do. all the other matters involving civilians, we have competent courts that are guided by the Constitution, and those courts are established by various acts of parliament. And our Constitution guarantees a person the right to a fair hearing, right to be heard. Unfortunately, under some regimes where court martials operate, such rights are limited. Where an accused person has been taken there, they may not enjoy the right to a fair hearing. For instance, what is happening to Kizza Besigye. He's not enjoying the right to fair hearing because charges have been given. He's not even being allowed to be given bail. His advocates could even be restricted to see him in prison. We have so many instances where the advocate went to see him and they could not be allowed, and they had cause commotion for them to be heard. He cannot be freely be allowed to perhaps even see visitors and even deal with some of his own matters. And it's been worse that even his own advocate was imprisoned by the court martial and is serving a 9-month sentence. And that court does not have the right for someone to appeal. In Uganda, for instance, the Uganda People's Defense Forces Act, it's called UPDF. That act does not allow the right to appeal. So if you've been condemned by the court martial at first instance, you can only appeal within the court martial. So you can imagine if the panel is already unfair. You can only appeal within the court martial. You can't even go to the high court. So you can't receive fair hearing where it's already been predetermined as what is happening to Kizza Besigye. And it's really unfortunate, which Kenyans should really know, that the Supreme Court of Uganda on 31st of January 2025 issued a judgment in the case of Attorney General versus Michael Kabazira. Yes. So in that judgment, the Supreme Court held that all those matters, it found it unconstitutional for the court martial to try civilians because they can't get fair hearing. And for that reason, it held that all pending civil matters be transferred to civil courts. And anywhere where someone has been condemned or sentenced and they have challenged it, those matters they should be heard by the civil courts. Yeah, but unfortunately, even with that judgment, Besigye is continued to be detained. Unfortunately.
And we'll be getting much into that particular discussion, looking into the jurisdiction in Uganda and how it is playing out in terms of, violations of human rights. But here in the country, a preamble into the discussion of court martials. For the KUTV, you've mentioned that court martials are primarily to look into disciplinary issues. Therefore, is there some sort of an appeal mechanism in that particular, sort of way of handling the cases? And can a KDF personnel look into moving to the civilian court if at all they feel the court martial has not given them a fair hearing? Can they, swap in some sort?
Thank you so much. The KDF Act is comprehensive and it provides for an appeal mechanism. A person who is aggrieved by the decision of the court martial can appeal to the High Court within 21 days of the decision. And in fact, the Act even goes ahead to say that any person who's been sentenced to death under the court martial should never be executed unless that appeal period has lapsed. And maybe they didn't appeal. They should never be executed. And perhaps if the government so wishes, they can be granted mercy if that is available. So the Act allows the appeal mechanism so that if you're not happy with a decision of the court martial, which is a subordinate court, you can appeal to the High Court. And there's a comprehensive process how the High Court can hear, determine, either set aside that decision or perhaps reduce the sentence, among other things.
All right. So the 2010 Constitution has been termed as one of the best legal documents that we have world over. And previously, before we had the 2010 Constitution, were people being tried in court martial? Was there some sort of incidences that we saw, like what we're seeing in Uganda right now? Because Kenya's is a mature democracy, and maybe that used to happen previously before we got here.
Thank you. I'm only aware of the 1992 coup,
Okay.
where soldiers were tried in a court martial. I'm not aware where civilians have been tried, but in other jurisdictions, for instance, Nigeria, Mali, there has been trials in the court martial, and people's rights have been limited because, especially where a government has taken power through a coup, the rights of accused persons are really limited, so that when you're taken to a court martial, you can't enjoy rights of an accused person. For instance, under Article 49 of the Constitution and 50, fair hearing is limited. Your right as an accused person to bail and other things are limited. Yeah.
All right. So you mentioned that for a civilian to be tried in a court martial, they have to write a consent that they have actually agreed to have, a hearing in that particular court. When you look into situations whereby civilians have been tried in military courts, can you say that there has actually been a fair hearing compared to other jurisdictions where a court martial is actually a usurp of human rights and a violation of the law?
Thank you so much. The KDF Act requires that there are some of the things that they have to take into consideration, and one of the things is to ensure that the accused persons enjoy their rights under the Constitution.
Okay.
So that an accused person has to enjoy the rights under Article 49 of the Constitution. They have to enjoy the rights to fair hearing under Article 50 of the Constitution. Because if that court does not do that, then that accused person, if he moves on appeal to the High Court shall quash the entire decision of the court martial because it will be unfair. So based on that, because that act was aligned with the Constitution, if there have been any civilians who gave their consent to be tried under the court martial, ordinarily the hearing will be fair and free, and if they are not happy, they can appeal. And in any event, the court martial has a competent judge who's appointed through a judiciary process, because court martial is part of our subordinates, which is very different in Uganda, because in Uganda the military personnel are the people who sit as the chairman of that court. And you can imagine it cannot be fair because those people have not even been appointed through a process that is free. So they are subject to pressure from the executive or above. Let me just call it above. So that then really raises questions as to whether that court is able to guarantee an accused person a fair hearing.
Right.
Yeah.
So when they appeal to the High Court, now for KDF personnel we are talking about right now, do they go up to the Supreme Court, or does the process, close at the High Court? Do they go through the Court of Appeal and the Supreme Court?
Thank you. I'm not aware if that avenue has been challenged. The Act only talks about the High Court, but then an interpretation of that Act would mean that if you're not satisfied with the High Court, you can move to the Court of Appeal, you can move to the Supreme Court, but only under the Constitution, because the Constitution provides for the High Court and other superior courts. And the KDF Act says that a person can appeal to the High Court and the superior courts. So my understanding of that could mean that you can appeal to the High Court. If you're not satisfied, you can appeal to superior courts, including Court of Appeal, Supreme Court, provided you are meeting the requirements of an appeal. For instance, appealing to a Supreme Court, there are ingredients under the Constitution which one should satisfy. For instance, the matter should raise public importance. It should be certified by the Court of Appeal, among other things. So if someone meets all those, I think they are allowed to appeal. However, that should be challenged, because once it's challenged, we will have a jurisprudence as we have in the election matters, where in election matters it's clear that for instance, MCA, you can't appeal from High Court. A decision of High Court is final. So this KDF Act has not been put into serious litigation for us to really determine whether the High Court is the final court or one can still
appeal to that particular stage. And in that, you mentioned that a court martial is a subordinate court, and in other jurisdiction, military personnel are the judges in a court martial. Here in Kenya, is there any sort of additional training or specialization when it comes to the judges that sit on court martial, given that this one is entirely, I would not say entirely different, but some sort of a special court, and also given the question that, given that KDF issues are largely issues surrounding security and also intelligence, and there is also some sort of a way of covering some of those issues for security reasons. Is there any specialization for judges to sit in court martial? Thank you.
Indeed, there is specialization. For a judge who is to be appointed to the court martial must have expertise on matters of KDF. It could be a military personnel, but is an advocate who is qualified, who, according to the KDF, requires to have not less than 10 years experience, and he could fit to be appointed as a registrar of the Court of Appeal. Yeah, so if a KDF personnel meets that, is a lawyer and he has all that qualification, he can be appointed. And in fact, that act requires that if a matter has gone on appeal and the High Court feels that it needs expertise of a military, from the military sector, they can bring in an expert. Yeah. So my understanding is that that judge should have expertise around matters of defense. Right. Yeah, it's just not any advocate. What happens then for the parties that form that particular case? In a civilian court, we'll have the respondents and also the interested parties as well as the legal counsel. Is there any sort of specialization as to a lawyer who can represent you in that court of law, given the sensitivity of issues that are handled in that particular court? Thank you. I think so. It depends on how the accused person would wish, because it depends on the wishes of the accused person. They are free to appoint a lawyer, but of course you would want a lawyer who is experienced on the area of law you've been accused. Yes. But ordinarily advocates can swap in any matter freely, but there are those who are quite experienced. So it depends on the accused person. If they wish to have an experienced person, there are some advocates who are not experienced, but when they are given a matter, they can execute. Yeah, so in terms of parties, a court martial is normally criminal because it only deals with the disciplinary. So interested parties and other parties may not really be part of the proceedings because it's just criminal. All right. Thank you so much, Advocate Emily, for that. We'll be taking our first break on that particular note, but don't go away. After this particular break, we'll be looking into Besige's case and why he was being tried in a civilian court. What other regional jurisdictions say about civilians being tried in military courts? See you on the other side of this break.
Swala ibuka ni kuwa wazee kwa njia moja au nyingine wametelekezwa. Wiki hii tunamwangazia Joyce Mopero ambaye amejitolea kuwa wa msaada kwa wazee katika jamii.
Tunaweza wakati mwingine ona kama hawa mama wazee na baba wazee, kwa sababu wamezaa, wako na watoto, wako na uwezo na wako na watu wa kuangalia, takuja kujua kumbe wengi wao hawana.
Usikose kutazama kipindi cha Mwanamke Mwake kwa uhondo kamili, ukiwa nami Caroline Kimwele.
Maelfu na maelfu ya wahamiaji wakiwa na watoto kutoka nchi za Amerika ya Kati wanaendelea kuwasili kwenye mpaka kati ya Marekani na Mexico.
But folks, I'm going. Thank you very, very much. I appreciate it. Thank you.
Ni habari kutoka pembe zote duniani.
Pepopa si vuguvugu. Pepopa ni idea.
Sazidi ananyonya, hanyonyi vizuri, anakuwa hayuko comfortable.
Jeshi la Jamhuri ya Kidemokrasia ya Kongo linapambana na waasi wa ADF.
Kwa sasa wanatoa wito kwa mashirika, makampuni na vile vituo vya uchukuzi.
Mambo mengi yatakwenda kama yalivyopangwa.
Hapa ni kuna mmoja wa viongozi wa chama cha wavuvi katika eneo hili.
Zaidi tunajaribu kuwapa chanjo ili ina boost ama inanyanyua kinga ya mwili, hiyo inaenda kupelekea kupambana na virusi.
Ni Duniani Leo, Jumatatu mpaka Ijumaa, moja kwa moja kutoka VOA Swahili, Washington DC.
You're watching Law Matters. Tonight we are discussing the issue of civilians being tried in military courts, what is happening in Uganda and whether it has happened in Kenya and what regional jurisdictions say onto what is happening. Now, Advocate Emily, I want us to look into Besige's case. If you're just tuning in, Advocate Emily was one of the people who were sent as observers to look into Besige and what is happening to him at this particular moment. So, Advocate Emily, what do you read from what is happening in Uganda in terms of Besige being tried in a military court? Looking into the accusations against him, was that, the best legal route to look into the matter?
Thank you. Besige was bundled from Nairobi.
Okay.
He had visited Nairobi sometimes in November 2024, abducted by the Kenyan police, handed over to the Ugandan police, taken to a court martial. Some of the charges was that he was in possession of a firearm with the intention perhaps to commit an offense. Looking at it, of course, it was a predetermined process to silence him, being he's a political figure, and considering that right now Uganda is going to election early next year.
Yeah.
So that was an approach that was taken, and since November he's been detained at Ruzira prison. He's never been given bail. All his requests have been declined. Even his advocate, who was trying to oppose those proceedings, was also condemned and imprisoned. It's really unfortunate that all that has happened under the watch of not only just Ugandan authorities, but even the international community.
Right.
It's really unfortunate that even Kenya's fingerprints on Kenya is involved in that process.
And when you look into the charges, and of course maybe you have perused the Ugandan law, given the interaction as an observer, and one of the lawyers sent there by a lawyer's body, do you think the charges to, possess a firearm is enough for what is happening, given that it is allowed in their country for civilians to be tried in court martials?
Thank you. I've looked at them. Those are our offenses under the Penal Code, if any. We didn't see any evidence. We only saw a charge sheet, allegedly charge sheet. We have not seen any evidence. So I may really not comment much. But looking at the charge sheet as it is, I found that that was an offense under the Penal Code and ordinarily should have been charged in the ordinary courts.
Okay.
But taking him to a court martial was a calculated move, because in the court martial, he will not, most of his rights have been limited, including the right to bail. He will be detained as long as they wish. He will not have a right even to access his counsels as he wishes. They only allow him to access his lawyers, and sometimes that is declined on only Mondays and Wednesdays. Sometimes even opposition figures from the opposition have gone to visit him and it's been declined even if it's on that day. So you can imagine most of those rights are limited. So him being taken there was a convenience of just limiting his rights. Yeah, not just taking him through a fair hearing. And that's why the Supreme Court of Uganda, in the decision of Attorney General versus Honorable Michael Kabazarugira Ruka, said that hearing of civilians in a court martial is unconstitutional because it limits accused persons' rights, even to a fair hearing. And going forward, the Supreme Court ordered that all civilian cases should be transferred to ordinary courts. And the time we visited, we found that as soon as the decision of the Supreme Court was out, the court martial had to halt the sittings, and then nothing has happened to the accused people. They were not released. They are still in detention illegally. They were taken to the High Court, and when the court found indeed they were illegally detained, the next day they were being taken to a normal ordinary court. And then now what the High Court found thereafter in its ruling is that now the question before it is now moot because they have now been charged. So it's really unfortunate. And as we speak, I'm aware that the Parliament, the majority party, is discussing to amend the UPDF Act so that now they allow court martial to again try civilians, but then provide for an appeal mechanism against the decision of the Supreme Court. It's very unfortunate.
Very unfortunate that democracy and even the leaders themselves are not doing anything to make it better, to be of standards in terms of human rights and statutes that, you know, have been signed into globally. But we saw him go on a hunger strike, and of course that was a message. He was trying to send out a message. He was crying out loud without actually doing so. And some saw it as a message to the international community to actually wade into this particular matter. Now, observing the situation and how the issues were moving during that particular time, did the international community actually, you know, come to the plea of Besigye, given that the laws in the country actually sort of failed to protect him?
Thank you so much. Indeed, the international community has put pressure on the Ugandan authorities and really helped in the fast tracking of Besigye's being charged in an ordinary court. Of what happened, that he was now arraigned in a magistrate court. That has really helped. Why I'm saying that is that there was pressure that was even mounted on the head of state. And he had to do a reaction by doing a letter saying that he should not be pressurized by some organizations. In Kenya, we have had demonstrations and pressers on what is happening in Uganda. So that is just not what has only happened. We have had even demonstrations in Canada. I'm aware of pressure being mounted from other countries.
Yes.
So people are really watching in terms of what is happening in Uganda, because for instance, as East Africa, it affects us because Uganda is a member or a partner state of East African community, and it's committed itself to comply with the treaty, but unfortunately it's not. So we had to speak up, not only just lawyers groups, human rights groups, but even some government pressure was mounted from other countries. So I'm really glad that out of that pressure, as much as Besigye has not been released, but the pressure will continue, but then at least he's been arraigned in an ordinary court where now new charges were brought of treason. Yeah.
All right. Now, looking into the legal framework there and also looking into the treaties that they have signed, is there some sort of an alternative route for Besigye, given the charges against him, and actually a time where there is some sort of political pressure and interest? As a lawyer, is there some sort of a alternative route for him? And can one file a case at the International Criminal Court to sort of intervene into what is happening in the country?
Thank you so much. There are alternative routes under international law. There is a mechanism under the East African Court of Justice, and as far as I'm aware, there are 3 cases filed by Besigye at that court. One is filed by some advocates on behalf of Besigye. So I'm aware that there is pending cases at the East African Court of Justice challenging Besigye's illegal deportation from Kenya, as well as detention and trial at the military court. There's also an avenue at the African Court on Human and People's Rights through the Commission, because Uganda has not signed a declaration which will allow individual person to access the court, but they can access the Commission. The Commission mechanism is still available. At the ICC, I highly doubt if there's jurisdiction, because that matter does not raise a jurisdictional question within the ICC framework. But as far as I'm concerned, under the human rights framework that we have, He can approach the African Commission on Human and People's Rights. He can approach the East African Court of Justice, which he has already done.
Yeah.
And also under the UN mechanism, we have a working group on illegal detention, which if he still approaches, it's also another available mechanism that he can be heard and perhaps a decision made.
Okay.
Yeah.
So how binding is it in the case where ESCJ will rule in his favor in the 3 cases that have been filed there so far? How binding is it for the Ugandan government to actually adhere to the ruling, given that a Supreme Court decision that has been made previously, in the case that you've mentioned, the Attorney General and Michael, has not actually been effected in terms of adhering to the court orders?
Thank you so much. I know the Ugandan government has partially complied with the Supreme Court decision, but not to the extent of releasing Besigye, to the extent only of charging Besigye in a civilian court. To that extent, they have complied, but there are other things they are doing. Now, in terms of ESCJ decisions, they are binding on partner states, and a partner state that does not comply with that decision, there are so many other routes. It can even be suspended from the community or even expelled. As far as I'm concerned, for decisions from ESCJ that have involved Uganda before, where Uganda has been found to be in violation of the Treaty for the East African Community, Ugandan authorities have fully complied as far as I'm concerned. So that decision is binding, and if such decision is made, the Ugandan authorities will have no other ways other than to comply. Because if they don't comply, there are mechanisms to force them to comply. And one mechanism is to return the authorities back to court. They be declared to be in contempt of court, or through the summit, where they are either suspended or expelled, among other routes. So as far as I'm concerned, Uganda has always complied before, and this should not be a difficult one to.
And looking at that in terms of the goodwill, in terms of the partner states to ESCJ, given that this issue is political, and we have seen Kenya being part and parcel of, making Besigye to be where he is today, given that he had retreated in the country for a moment, and now the Kenyan government sort of exposed him, so to speak, arrested him, and took him to Uganda. From where you sit, do you think Kenya violated the rules in terms of the treaties that we have signed, in terms of people coming into the country, maybe for asylum or some sort of protection?
Thank you so much. Ordinarily, I may really not talk so much about it, because I know there's a pending case as we speak before the ESCJ on that issue, where Kenya is also part of the respondents. Ordinarily, when a party comes to Kenya, as Besigye came to Kenya through a legal process, he came legally. His passports were stamped, and he came to the Kenyan territory. He is supposed to be protected by the Kenyan government. He should not be abducted illegally and being taken. If Kenyan government was involved, let me just say there, and I stop there, because I don't want to really discuss a matter that is active and live before court, because I'm really not aware of the extent of evidence, so that I might be said that I'm condemning or giving
the issues of merit and the demerits of that case.
So maybe let me just say that ordinarily the Kenyan government has an obligation under international law that once people have come in legally, they have the right, or these people are entitled to be protected. Whether refugees or they have come legally, as Besigye came, they are supposed to be protected when they are within the Kenyan territory. Illegal detentions, all those violate international law, not just international treaties under the UN system, but even the East African Treaty. That is illegal. Yeah. So let me stop there. I wouldn't want to go into
that. And I will understand where you're coming from. When it comes to the East African, community, and also, regionally, given that we have a court in terms of the African High Court, in terms of looking into issues of human rights violation. Do you think, what have they said concerning this particular issue, and what has been the voice previously to sort of castigate the issue of civilians being tried in court-martials in this day and age?
Thank you. As far as I'm concerned, there has been voices from just not only within EAC, from even human rights groups across the region and in the African continent, condemning, even as far as Nigeria, condemning what is happening to BCJ, because honestly, it is a violation of human rights. I'm also aware of decisions of African Court on Human and People's Rights that have held that trials of civilians in court-martials are unfair and in terms of they violate human rights of accused persons, because they are not entitled to fair hearing and other rights that are accorded to an accused person. So looking at all that and considering the age we are in, honestly, that is a violation of human rights. Person should be a civilian person should be charged in a civilian court. I'm very confident that even Ugandan courts can really, they have the competence to try those kind of offenses. But taking them to court-martial is an avenue to cover up some issues.
Okay.
Yeah.
All right. And do you think there's a sort of mechanisms for civilians to oversight court-martials? And this is not only in Uganda, but also in Kenya or even Tanzania. Because as it seems, the lawmakers in Uganda are somewhat not doing a good job in terms of protecting the civilians, not to go through the violations that happened in court-martials. Is there mechanisms for this particular oversight? Because it somewhat seems to be a fine or a special court that the civilians cannot really have a purview of. What do you make of that? Thank you.
In Kenya, we have an oversight, a proper oversight mechanism through the judiciary process, because we have the High Court as supervisory jurisdiction over subordinate courts, including court-martial. And there's also an appeal mechanism which also provides oversight. But as far as Uganda is concerned, unfortunately, the Act sort of cut off oversight, because you can only be taken to court-martial. The only appeal, you can only be allowed to appeal to an appellate court-martial. So unfortunately, that oversight is cut off, because as a civilian, then once you've been condemned by the appellate, you have nowhere to go. You can only die of that condemnation. So it's unfortunate. But I'm aware of Ugandans who have taken it on and even gone to the Constitutional Court to challenge those as an unconstitutional process. That has also helped. And that one of the cases went all the way to the Supreme Court, which has provided a reprieve in terms of the direction such matters should take. That has helped, and it only took some of the courageous Ugandans to follow that process. But unfortunately, the Act as it is in Uganda, it doesn't really provide proper oversight in terms of civilians and the avenues they need to take.
All right. Thank you so much, Advocate Emily, for that. We'll be taking our final break, but do stay with us. We'll be having our tail end segment of this particular discussion. Do send in your questions and feedback. We'll be sure to read them in the final segment of this particular discussion, and also allowing our guests to ask questions. See you on the other side of this break.
Baada ya kutafuta kazi, tunaweza kuanzisha miradi yetu ambayo ingetusaidia kubadilisha maisha ya wazazi wetu.
Kwa vijana wenzangu, wengi hawana kazi, lakini ikiwa sisi wenyewe tutajiamini, tunaweza kujiajiri wenyewe.
Afrika kwa kweli tuna mahitaji ambayo ukiyasuluhisha unaweza kuathiri watu kwenye bara hili.
Bila uoga, watu huwa na uzalishaji zaidi, wanajawa na ujasiri, wanakuwa wabunifu na wanakuwa wenye maarifa.
Niliamua kuacha kazi, hata kama sitafanikiwa, nitakuwa nimejaribu, nitakuwa najua haiwezekani.
Hakuna kitu cha ajabu hapa. Kila anayepata ufanisi hufanya kazi usiku na mchana.
Kitu kitakusukuma na kuwezesha kupata maarifa ambayo hukuwa nayo.
Tunajaribu kutengeneza kitu kitakachopita mipaka ya nchi hii.
Ikiwa unataka kubadilisha ulimwengu, anza na nyumbani.
So my name is Jakub Petri. I'm Associate Professor in the Institute of Philosophy of Jagiellonian University in Krakow, Poland. And I'm the main coordinator of the CAFE project, which is being here hosted by Kenyatta University.
My name is Eva Hudoba. I am a project manager in this consortium. Keep watching cutting-edge research at Kenyatta University Television.
They are powerful and influential. They make decisions in politics, education, finance, agriculture, health, sports, and all aspects of human life. But the impact of their decisions falls on you, the common citizen. KUTV Primetime News Thursday. We ask bold questions and pursue answers to the core to bring you closer to the story. We couldn't have it any other way. Join me, Auma Evans, as I raise matters of social concern to raise your voice from the background to the foreground.
Welcome back. You're watching Law Matters. We're on the tail segment of our discussion tonight, looking into civilians being tried in martial courts and what is happening in Uganda at the moment. At this particular time, we allow our audience to ask questions, and I will throw it to them at the moment.
This opportunity. My name is Eugene Bill. I have one question. And for the purpose of clarity, articulating what the NAC leader Mother Karua in today's interview said in regards to the case of Dr. Kizza Besigye, on what he said that we people of Kenya, we are the ones who allowed Besigye to be detained. Do you think that there are some of the provisions that are being violated and some legal statutories? Thank you.
All right, thank you so much. Do we have another question?
Thank you for this opportunity. My question is simple on the rules of procedure in the court martial. Are the rules of evidence the same as in the normal courts? And also, what are the major penal sanctions? Are there fines, or is it only imprisonment and detention? Thank you.
All right, thank you so much, Advocate Muli. Kindly answer those two questions from our audience.
Thank you. To the first question, if Kenya is really found to have illegally abducted Besigye, if that would be the position, that would be illegal under the East African Court of the East Africa Treaty for the establishment of the East African Community, because that treaty requires that partner states should uphold rule of law under Article 60 and 7.2. So that will be a violation of rule of law, because once a person travels from Uganda to Kenya legally, they are supposed to be protected. We even have the common market that allows people to come in freely and go back. Yes. But if they are being abducted from here without following the process, that then violates not only the treaty but even the common market protocol. So that will be a violation of those treaties. And I'm only talking about the ESCJ case because I'm aware of that, and it's still pending. Under the African regime or legal, under the Banjul Charter, it's also illegal, as in where someone has been illegally detained, illegally abducted, as well as his rights to fair hearing being limited. That is illegal if you would approach it through that route of the African Commission. So that is what I can say as per now. I wouldn't want to go into the merits of the case. Please allow me to stop there. Okay. Now, in terms of the court martial and the rules of evidence and the offenses, in terms of sentences, let me start with the sentences. There are many other sentences. A person can be detained. Under KDF Act, an accused person has a right to bail. They are supposed to be granted bail. The court martial should follow Article 49 of the Constitution. If they are to decline bail, the court has to give reasons, or those compelling grounds have to be satisfied where they would deny bail. So detention shouldn't be a position. So in terms of other sentences that are available, a person can be imprisoned or sentenced to particular years. He can be sentenced to death. That is also a sentence that has been provided. If you look at Uganda, those are there, among others. There are so many other ways they can, including detaining a person, sentenced to death, among other sentences. Detention and sentence are not only the only sentences. There are many others. So in terms of rules of evidence should be used for Kenyan. I'm not very sure about the Ugandan if they follow the rules of evidence, but in Kenya, remember the burden of proof in criminal matters is beyond reasonable doubt. So that should be followed by a court, and considering this is an accused person who has been accused of an offense. So the people are charging him should prove beyond reasonable doubt that this offense has been committed. That should be complied with. But in Uganda, considering the system in which they are, things may not happen as we would expect in terms of a free society, and where the judiciary is independent and does its matters freely. But ordinarily, that should be the standard.
All right.
Yeah,
thank you so much, Advocate Emily, for that, answering the questions by our audience. But you have mentioned a bit about the East African Court of Justice, and this is not even what is happening at the moment, to avoid getting into the merit and the demerits of the 3 cases filed. But looking at it previously, these partner states have different sort of laws. They have different sort of laws that govern them. And therefore, even if the decision by EACJ is binding, there might be a tiff when we look into the the different laws in the separate countries. Does that interfere with that, and how does it go, especially in a country like Uganda, where in civilian court people are not allowed to have bail, they're not allowed to access legal counsel? How then does a decision by EACJ sort of overturn what is happening in the country?
Thank you. Let me start by saying that when East African community was established, there are pillars and principles that guide that community. And one of the pillars is to ensure that these partner states uphold the rule of law, and as well as ensure that there's harmony in terms of they should not act in a way that jeopardizes the realization of the objectives of the community. So where one partner state acts in contravention of the treaty, that affects the fully realization of the treaty. And those decisions help to harmonize, because they correct and help harmonize how a treaty should be enforced by all of them, so that when the one decision applies only maybe to Kenya, that should be applied across the board. And I'm also aware that even our national courts have applied the East African Community Treaty to help harmonize that, how treaty provisions should be applied. For instance, recently, on 31st of January 2025, the High Court in Nairobi, the Constitutional Division, issued a judgment in the case of Law Society of Kenya versus Attorney General and others. In terms of that decision was that appointment of judges to the East African Court of Justice under the Kenyan Constitution should be done through the Judicial Service Commission. And that person should be subjected to interview and scrutiny, so that they can't just pick one person and just fix him there. So that decision has huge implication, because how perhaps it shapes how even Tanzania does, because our law in Kenya is almost the same as how Tanzania appointment of judges is done, and Uganda and maybe Rwanda and Burundi will follow suit. So that could also help in achieving the harmonization and the implementation of the East African Community Treaty across the board.
what were the grounds for that particular case? Was it to cure or quell a certain situation that was happening in that particular court to an extent that there needed to be some sort of a legal, threshold and framework for appointment of the judges? And even if our law is all more or less the same with Tanzania, how will we ensure that this particular court order is binding in the 3 partner states?
Thank you. What happened was that that only challenged Kenya's nominee to the East African Court of Justice. The executive nominated someone. He was just handpicked.
Okay.
There was no interview. That position was not advertised. JSC was not involved. Then the person was nominated, but then the Law Society filed a constitutional petition challenging that appointment, nomination, sorry. So out of that, then the court found that that process was unconstitutional because it did not comply with the Constitution. So that helps because perhaps Tanzania, how they are nominating, previously judges have been handpicked.
Yeah.
And I'm aware of a case which was challenged by the East Africa Law Society at the ESCJ, challenging a nomination of a judge from Tanzania called Mujasiri. And unfortunately, she had been already appointed by the summit, so they couldn't do so much.
Yeah.
But then this decision of Kenya might shape how other countries nominate and appoint judges to the ESCJ, because they might need to look into a process which is free and transparent and competitive. Maybe out of this decision, Tanzanians will challenge a next up a nominee, or Ugandans will challenge. There will be various challenges, or they might need to look at what has happened in Kenya and perhaps use the process that Kenya will be using to nominate a judge to the ESCJ through the Judicial Service Commission.
Was there really some sort of a loophole, given that previously, until this particular nominee was sent to the ESCJ, previously it was not something, to cause a hullabaloo? It has, previous regimes have conducted themselves the way this particular regime has done. Was there some sort of a lacuna in terms of the appointment of judges to that particular court? And did it point out to lack of seriousness in terms of the weighty issues to be presented to that particular court?
Thank you. The Treaty of the East African Community has left the nomination process to partner states to do it according to their own law and regulations.
Okay.
So that has left a lacuna, because how South Sudan would do it, how Tanzania would do it, how Kenya would do it is none of our business. Yes. You bring us a nominee, but comply with your law. So that has really left a loophole, because the executive could sometimes just wake up, look at who pleases them at that moment, and they take that person even when they don't qualify for that position. So that has been a challenge, and perhaps out of this decision of the High Court of Kenya, that could shape how matters happen going forward, unless maybe that decision is challenged at an appeal stage. But as far as I'm concerned, there has no appeal has currently been lodged against that High Court decision.
All right, and I'm sure our viewers are wondering how we got to the ESCJ in a issue looking into court martials in Kenya, but looking into Besigye's case, it might appear like the ESCJ will hold some sort of ESCJ cases filed by lawyers who are his allies will form some sort of a weighty decision on the way forward. Now, as we're winding up because of time and looking into how you saw the situation in Uganda and observing what happened there, do you think even him being taken to an ordinary court and the charges against him, treason, it is quite a weighty sort of an offense? Do you see a situation whereby there'll be a way out in terms of the weight of evidence without looking into the particulars in terms of that particular case?
I've not seen, I only saw a charge sheet that was filed by the DPP, which it was on that basis that he was taken to the court. So we are yet to see the evidence that the government will, or the Attorney General shall provide.
Once it is hard?
Once it's ready, we are yet to see. But there's skepticism in terms of whether that process will be free and fair. There are allegations that the judiciary might not be very partial because some could be taking orders from above. So we really and pray that the courts in Uganda will stand firm, will uphold the rule of law. They will ensure that the accused persons receive their rights. They are accorded the rights to fair hearing. The accused persons are also accorded the bail. If they deserve, there are no compelling grounds. And we hope that they will stand by the rule of law and their constitution.
All right. Yeah. Thank you so much, Advocate Emily, for giving us a perspective on this particular topic and, of course, giving us your insight, having been, presently in Uganda, seeing what is happening to the opposition leader, Kizza Besigye. Many thanks indeed for making time.
Thank you.
All right, there you have it. Looking into this, what is happening, it will be, a lookout into what will happen to Besigye in Uganda. And not only that, but also the cases that have been filed in the East African Court of Justice. With that, have a splendid night. My name is Irene Mwangi. See you next week, same time, same place.
Are you an aspiring media practitioner, a graduate, or you just want to advance your skills in television production? Then welcome to Kenyatta University, where education meets innovation. KUTV, the premier university television station in Kenya, is now offering short courses in TV studio, field technical operations, and video editing. Through these courses, you will acquire hands-on skills on camera operations, media production, lighting technology,